Well, very good morning to everyone, and welcome to this webinar on Record of Default by National E-Governance Services Limited. On this webinar, we will discuss how NeSL's RoD can aid admission of corporate insolvency resolution process. The session will be presented by Sri Surendranath, who is the Head of Relationships, Public Sector, Information Utility, and Digital Document Execution. And also, he'll be joined by Srimati Suparna Chaudhary, DVP of Operations. The session will be presided by Sri Devjyoti Roy Chaudhary, MD and CEO of NeSL. Now, before we begin, please ensure that you follow some hygiene practices to ensure a smooth session. Here are some suggestions. Just please keep your phone switched off. For all people who are curious about some specific questions, we will have a 10-minute Q&A session at the end of the presentation. And anybody wishing to speak can raise their hand or to ask their question, and we will unmute you to be able to ask your question. Alternatively, you can also leave your question in the comments box. And towards the end, I will read some of those questions and have them answered for you. Now, without further ado, I'll request Sri Devjyoti Roy Chaudhary to give us the opening remarks for this session. So over to you.
Thanks, Gurdeep, and good morning to all participants who have joined this webinar on record of default of the information utility. And I welcome all of you, and I hope you have a very interesting and interactive session. Information utility, if you have heard of it, it is regarded as one of the pillars of the code, and it is often said to be a unique Indian innovation. And if you see the website of a regulator, Insolvency and Bankruptcy Board of India, in the website, in the introduction about the IU, it is said the information utility has no parallel anywhere in the world. I also use the word unique. So what makes the information utility so unique? We have many similar repositories in India, but what makes the information utility very distinct from the others is a couple of things. I'd not like to dwell on all of them, but I'd like to dwell on some of them, which is of specific relevance for this webinar. Firstly, information utility is a very equitable institution in the sense that it gives all parties an opportunity to submit information and also give the response to any information submitted in respect of them by some other party. So if you're from a bank or NBFC or from any other creditor and you've submitted some information, whether it's of debt or default, the information to which it pertains to the debtor, so he has an equal opportunity to accept it or dispute it. And that is why this is an extremely important source of information, and it's also of evidentiary value. In fact, there's another aspect to this evidentiary value, is that unlike many other institutions, information is submitted to the information utility under digital signature. Similarly, any other party who wants to give his opinion on the information submitted, so that party also has to submit his views under his digital signature. So both these two aspects, one, the fact that all parties have an equal opportunity to give their views, and two, the fact that information is only submitted to digital signature, is what makes information so critical to the adjudicating authority as a source of evidentiary value. There are many other unique features of the IU, and we have my colleagues here, very experienced, who will dwell on this aspect. I thought I'll just give you a brief snapshot. Now, today's session is also about the record of default of the information utility. Now, there are two aspects to this. Record of default is generated after you submit information. After you submit information, there's a process which the IU does, is provided in law, after which the record of default is generated. So today's session, we are going to talk about two aspects. One is submission of information, which is also important because sometimes I do understand some submitters of information face some challenges. So we'll dwell on this part also, that how to submit information. And the second and most important part is how to generate the record of default. I mean, all this, in fact, information utility is an electronic repository. All these are fully streamlined, straight through digital automated processes. So the record of default can be generated at your end. And if you have any issues, if you have any challenges, you can request us and we can also generate it and send it to you. And other thing I would like to tell you is that today, when we are talking of corporate insolvency resolution process, one of the things which immediately come to our mind is the delays associated with the process. And sometimes these delays are at the first stage, at the admission stage itself. So that is where the information utility can help. The RoD of the information utility can help. And how will it help? It will help because it gives all the information with the adjudicating authority. In the case of corporate insolvency resolution process, it's NCLT. It has all the information which the adjudicating authority requires to take a decision on whether to admit a debtor into insolvency proceedings. So again, there are two aspects to this. One is, of course, the law makes it mandatory to submit information to the information utility if you decide to initiate corporate insolvency proceedings against a corporate debtor. So first part is law. But the second part is it also makes things easier for you. Because since you want to initiate insolvency, I'm sure you like the process to happen as quickly as possible. And that's where the IU can help. And as I said before, it has all the information, because to get the same piece of information, you would possibly need to provide tomes of paper. Instead of that, if you take the IU, you'll have all the information which the A requires. If you give excess information, that's also a challenge, because then if you give more information than what is required by the adjudicating authority, then they will by force have to go through all the information, and that will also be time consuming. So the information that the record of default of the IU has the information in a digital, in a paperless, in a form which is easily retrievable. It can be easily downloaded by you. It can be easily submitted to the adjudicating authority, and therefore it can actually help in the admission process. And RoD is one part, but the other part is, some of you may say that no, but I don't want to initiate corporate insolvency proceedings because for whatever reason. Because at the end of it, most of us, if you are having, if a creditor does not pay us, what we are also concerned is that we should get back our money. If you have lent some money to a corporate debtor, we should get back our money. And that's where the information utility can also help. So let me clarify. If you need to initiate insolvency proceedings, information utility can help by giving you the record of default. But in case you do not want to initiate insolvency proceedings, this could be a case, for example, the threshold for initiating insolvency proceeding, corporate insolvency resolution proceedings is 1 crore. Suppose the threshold is below 1 crore. even then, information security can help if you submit the information of default. In fact, after a due process of authentication, the information security sends a default broadcast messages to all the creditors of a debtor. So the default may be to one creditor, but once the default is authenticated and as provided in law, all the creditors to the debtor become aware of it because of this broadcast given by the IU. And again, this is incidentally another unique feature of the IU in the sense that it gives notifications. This is one of the notifications. You can always, as a user, you can register into the IU after identifying yourself, after giving some documents and see the information. But IU also sends you various notifications, and this is one of the notifications when the default has happened to one creditor. You are assuming you are a creditor to whom default has not happened. But even then, you will get a broadcast that the debtor has the same debtor has defaulted to some other creditor, and this will help you. It can help you mitigate your risk. You can take additional collateral. You can ask for additional margin. You can, if there are undisbursed limits, you can decide on further dispersal of them. So this becomes a very useful credit management tool. So to sum up, in this webinar, we'll explain to you, one, the importance of the IU, and two, how to submit information to the IU, especially information of default. Then we will also tell you how to effectively use this record of default, how to download it and use it for the purpose for which it was designed to be used. One final concluding remarks before I hand it over to Gurudeep. As I said before, IU is a very unique institution. It is also an infrastructure of national importance. As I said, it's an equitable institution. It is there for each one of us to use. And unlike many other institutions, anyone can submit information to the IU. And information, if your creditor submits information in respect of you, you have an opportunity to give your opinion on the information submitted by the creditor. So this is an institution which is there for us, and you can also use it. So please do use it. So with that, I will conclude my remarks, and I hope that you have a good session and will gives you more understanding of the subject. And we always welcome for any questions, any doubts, either through this webinar or even otherwise through our various social media platforms, and of course our usual emails. Okay, thank you and welcome, and I hope once again that you have a good and interactive and a session where you can develop your knowledge. Thank you.
Thank you very much, sir, for that. Now I'd like to invite Sri Surendranath, sir, to give us some insights about information utility and how it pertains to record of default. So over to you.
See the people who have joined is exceeding 100, and I must really thank all those participants who have come to this webinar. Thank you. I will be taking the initial part of the discussion today, give the background of why the entire thing started, and maybe the framework of these regulations. And later part, Suparna will be taking over. She will be advising the formats, the various login screens that are there, and other details, the issues that come up, and what our questions and answers we'll be taking at the end of the session. Now, as you are aware, we'll be running into some abbreviations as we go along. Some abbreviations that, one we are already seeing on the screen is the RoD. So that's a record of default. That is the basic purpose of this discussion. The second part is we'll be talking with the IU, the information utility. We are an information utility. We are the only information utility in the country. And like our MD has already said, this is a unique concept in the world. Suparna, maybe you can put the first slide. Am I audible?
Yes, sir.
Yeah, first slide, please. Yeah, this is what the unique innovation, Indian innovation. It is not there anywhere else in the world. Many countries, most of the developed countries have a bankruptcy code. India, in that fashion, has been a late entrant. It was only in 2016 that it was received the assent of the president, and the gazette was issued on 26 May 2016. And when IBC was conceptualized, the basic objective of this was the reorganization and resolution, maximization of value of assets for the persons to promote entrepreneurship, enhance availability of credit, and balance interest of stakeholders. So it is not in the sense that we are trying to recover and advance. We are trying to safeguard the economic value of these assets. Because what was happening earlier is, you are aware of our experiences with various schemes of restructuring that we had. Either it was under the SICA, the BIFR, the CDR, the S4A. They were, in the sense, once a company got into any of these schemes, it continued as in perpetuity. In the end, what happened was that the banks would lend more and more to those companies. The management would retain control of those companies. And if you went for a recovery process through the courts, the time frame was quite enormous. In fact, sometimes we might file a case, and by the time it came to resolution, we might have retired from our organizations also. So that is the sort of time frame, and what created these sort of issues as regards the time frame was basically the borrowers tend to dispute everything that is filed in the court. And basic thing starts with the lawyer filing. When you file your case, the lawyer's first thing is he disputes that he has ever executed, and the borrower will say that he has not even executed the documents. He has not signed those documents. He has not taken the loan. This is standard counters to whatever the bank files. This actually kept the entire ecosystem in such a limbo that for years we could not find resolutions to many of these large assets. Think of what has happened recently. After the IBC came in, look at those large assets, where we could find some resolution. Without naming names, some of these assets are running into tens of thousands of crores. Had we gone to court, what would have happened is the management would have retained control of those assets. And as we know, in most of these cases, by the time resolution comes through, those assets would have disappeared. The current assets would no longer be there. The physical assets also sometimes are secreted out, sold off, and the banks at the end are left with very little. So with an objective that these issues are addressed and resolution and recovery being secondary, but basically this economic assets would be retained. The Banking Law Reforms Committee, if I can quote them, when they conceptualized the course, the rationale was all parties need an accurate and undisputed set of facts about the existing credit and collateral that has been pledged. And they say under the present arrangement, considerable time has been lost before parties obtain the information. The disputes about these facts take years to resolve in courts. It's a fact. All of us have faced those sort of things. I remember in my earlier days, I'm an ex-banker. When I attended a court, the borrower would say that he has not executed documents, he has not signed. I remember one case where he even disputed an affidavit he had filed himself in the court. So that is the sort of litigation these people get into. Issues don't get resolved. So the amount of loan he has taken, that he has executed a document, are one crucial things that has been delaying the admission into the case into the court, and resolution of those assets. So we know the timeframes that this take. Keeping this in view, now what is the role NeSL plays? Actually, under the IBC, there are four pillars, like our MD has already pointed out. There are four pillars. One is the regulator, the IBBI, Insolvency and Bankruptcy Board of India, and it actually regulates the IPs, insolvency professionals, IPAs, IPEs, agencies and enterprise entities, and the IU also. It writes and enforces rules and processes, namely CIRP, corporate liquidation, etc. The other is one more abbreviation we keep on using is the AA, the adjudicator, educating authority, which is the DRT, the NCLTs, and the Supreme Court overseeing all of these. The third is the insolvency professionals. They play a key role in the efficient working of the entire process. Both comes the information utility, NeSL. Now see, NeSL's basic role is, we have created electronic database. The purpose is to eliminate information asymmetry. What happens is over various, when you file in the code, for the code to identify that there's a default there, the outstanding is correct. These are things that have to be verified. Now, if there is an assured, a certified, an authenticated set of information the code can rely on, it is always easy and fast for a code to accept that information and move on. The IBC process also makes the entire process, time bound. Now, compared to what happens in the code, if we are able to get our filing into the code and the code accepts it, the process of resolution is much faster. This in fact helps to reduce the disputes that generally come up in such a process. So that is where our RoD comes in. Now, see, in addition to that, the core idea of this process is that we act as an information aggregator. We get information from all the financial institutions, the banks, and this, as we go along in this presentation, we see there are some guidelines and some requirements, obligations, both from your end, in the sense that the financial creditors have to follow, something that we have to do, and an understanding of this will help to speed up the process. Now, as we already pointed out, we are a regulated entity. And in fact, if you look at our shareholding also, it is primarily of all the major banks, some of the insurance companies. So, we are working under the code, and the information that we have, we keep a information of not supposed to submit information at the end of the month, before the 7th of the next month. This is regular information that you have. That is, these are accounts which are running regular. In addition to also defaulted debt also. When there is a default in the account, that information also must be submitted to us. It can be against a person or a legal person, is a company also. And in addition to that, information about the assets on which you have a charge. There's also provision for you to submit the balance sheets, the P&L, the cash flow statements also. Basically, both data and documents are to be submitted by you. Next slide, please. Can we go to the next slide, please? Yeah.
So the slide has been changed.
Yeah. I think there is a lag for me to see. See, we are supposed to provide some core services. And section 3.9 of the code stipulates that we provide those core services. What are those core services? See, we accept electronic submission of financial information in a form and manner prescribed. Now, what are those financial information that we seek? We seek the record of the debt of the person, record of liabilities of the person when he is solvent. This is very important. This part that, you submit an information of the liabilities of a person when he is solvent. Basically, account is regular. And you will observe that, the possibility, because whatever information you are submitting to us, we get it authenticated. We send it over to the borrower for him to authenticate. He's still having his operations with you as a banker. And at that point of time, he's amenable to, your prodding and pushing and asking him to sign a document. In fact, when he takes a loan, he is ready to sign all sorts of documents that you put in front of him. So at that point of time, if you are submitting information of your regular accounts to us, there is a greater possibility that this information will get authenticated by your borrower. Even if he doesn't, you have information from us of those accounts which are not getting authenticated. You can always take up with him why he is not authenticating. It is a red signal for you in case he is not authenticating his information. His intent is one thing that comes out. So if you submit information monthly of regular accounts, it helps you to authenticate and keep that as a record, because this will help you if ever, unfortunately, the account fails. Then we also keep financial information regarding the records of assets of persons over which a security interest has been created. All those assets on which you have created assets, your mortgages, all those also can come here. And record if any of instances of default by the person against the debt. This is one important thing. The RoD basically comes from here.
Surinath, one moment. Surinath, this slide which is coming up is financial and operational debt. So is this what you are referring to?
Yeah, these are the type of debts that are there. In fact, the amount, the things that are covered. Okay, I'll come back to this. I wanted to just give an information, the services you're providing, and then from there, I thought I'd come here anyway. See, among the financial and operational debt, see, you might be giving cash credit, a term loan to the party. That information has to be provided. It can be a non-fund credit facilities too, in the sense that you an LC and a bank guarantee. Even those sort of facilities, those also can have to be reported. Secured or unsecured claims too. In the sense, they might have given an unsecured loan to the party, that also would get covered. Both domestic and foreign credit facilities. In addition to that, see, there might be cases where deposits are taken by in the non-financial sector. Intercorporate deposits might be there. Deposits were taken by companies. It also covers bonds and debentures, commercial paper, even loans given by private financial creditors. It also covers claims of home buyers. Not only are we covering loans given by the banks and financial institutions, and we also, in fact, information of operational debt, in the sense that, whatever the companies are raising, procuring goods and services, when payments are not forthcoming, defaults on those also will get advised to you. So all those claims of suppliers of goods and services, in fact, government claims, taxes and penalties, employee and workman claims, all these also get reported by us. And in the core services that we provided, this information is provided to us. We can provide information to all those creditors, who are lent to this debtor. Next slide, please. Here, see, when in the admission process, what does an AA, the adjudicating authority, look at before admits or rejects an CIRP application? Some of the main points that he has to look at, whether there's a debt at all. In both cases, whether it's a financial creditor or operational creditor, that obviously has to be proved. And whether there's a default. Now, that is where, a record of default obtained from us and authenticate with the authenticated information. If you can provide that, immediately the acceptance of your case in the court, in the NCLT, will immediately take place. In the case of financial creditor and operational creditor, both it is required. In the case of a dispute, in fact, in the case of dispute, banks actually stand in a better footing as compared to the operational creditor. The operational creditor, if there's a pre-existing dispute, it has to be proved that such a dispute is pre-existing before the filing in the court. In the case of a bank, there are settled cases where it has been taken that even if there is a dispute earlier, the case can be admitted in the court. In fact, NCLAT in the case of Karan Goyal and Pashupati Jewelers has taken a stand. They have taken also cognizance and also support from the earlier Supreme Court decision in Innovative Industries versus ICICI Bank. And they have taken a stand that in the case of banks, a default, a pre-existing default, cannot be a ground for rejection of an application filed by a financial creditor under Section 7. Then the date of default. Date of default obviously is related to the Limitation Act, 3 years. So that also has to be proved before it is accepted. Next one, please. Next slide, please. Now we have listed out the various provisions of the IBC. What are the obligations? If you look at section 214, the obligation IU to provide the core services. I was discussing those core services in a little earlier. The core services, as per 214B, if you look at it, to accept electronic submission of financial information from persons who are under obligation to submit financial information under section 215. Now 215(2), financial creditors' obligation to submit information. RBI has also issued a communication in this regard. And section 215(3), the operational creditors also may submit financial information. Now, what this actually helps is that, whatever information we are getting from either various banks or even the operational creditors of financial institutions, all this information actually gets authenticated. And when there is a default, we are in a position to pass on this information to you. And also when there are notifications, various notifications issued during the IPC process, either admission in the court, such notifications also get highlighted and passed on to the various creditors here. We already discussed that section 3.9, the core services and the financial information which is to be submitted. Under section 7.3 and 7.4 of the IU of the code, use of IU records in financial credit application. Basically, here 7.3 says that the financial creditor shall, along with the application, furnish a record of default recorded with the information utility. Now I will just, Suparna, can you just put up that NCLT order, recent one in April 2023?
Yes, sir. I'll just share.
This is the RBI one.
Is it
NCLT.
Is it visible?
NCLT.
Yeah.
No, we are looking at the RBI communication. Can we look at the NCLT order?
Okay.
This anyway, this has come. See, this communication also addressed to all the banks and financial institutions. It is a communication with the RBI asking submission of information to the NeSL so that authentication of the information can take place. Now, this order, recent order, you see it's dated 3rd April, issued by NCLT. Can we have it a little bigger? Just 1 second. Yeah, if you see the apical part, it says acceptance and receipt of information. Before filing an application to initiate corporate insolvency process under section 9, 7 or 9, as the case may be, I think it has become too big.
So it says 7 or 9, as the case may be, the creditor shall file the information of default with the information utility, and the information utility shall process the information for the purpose of issuing record of default in accordance with Regulation 21.
Yes. See, this is issued, there is an order from NCLT, and it requires that, you have to furnish this record of default to NeSL. We are the only information utility that is there presently. And we have a process of ensuring getting it authenticated as per the code. And once that is done, we furnish a record of default to you. So kindly keep this in mind that, not only the submission of information, the record of default, for the purpose of generating the record of default, you have to send us information of accounts that have been defaulted with you. Why that is important? For various factors. In fact, record of default submission by you for the purpose of your filing is one thing. Regular filing of information also helps you to get information of defaults with other banks, because we'll be generating those alerts to you. Okay, take this off and get to the slide. And section 7.4, where it also talks of, that within 14 days of the receipt of the application by the adjudicating authority, he has to ascertain the existence of the default from the records of the information utility. So once you submit your information of default, we get it authenticated, submit the RoD to you, and when you submit it to the courts will be able to, NCLT will be able to look at this and admit this case in case for further hearing. See why this is important, and if you look at the number of cases that are stuck at various stages before admission, there is a large backlog. It probably occurs because of so much of information that flows from various banks. Authenticating that information might be quite difficult. A recorded default actually takes that problem away. So submission of the information of default is very important. Now, section 8.1. An operational creditor may, on the occurrence of a default, deliver a demand notice. This is basically, for unpaid operational debtors. 9.3, for the purpose of operational creditors, a copy of a record with the information utility confirming there is no payment of an unpaid operational debt by the corporate debtor is available. So this takes care of, in the case of operational creditors also, the issue of record of default will definitely help immediate filing in the court. Then section 13.1b, it calls for a declaration. See, like I said, information that you provide to us, if there's a default with any other bank, not necessarily your bank, it helps to get an alert regarding a default that has occurred with some other bank. Similarly, during the IBC process also, there will be some pronouncements, public announcements that will happen. You will get information on those particular announcements. See, when under section 7 or 9, any case is admitted, a public announcement of the initiation of corporate insolvency, a resolution process, and call for submission of claims. Suppose you are not involved in that particular default, your account is regular, it will help you to get an information that somebody else has filed in the court, NCLT, for resolution of the IBC. It will help you to take necessary action and file your claims also. So kindly keep that in mind. This 15.2 and 18B and C are in the similar case that you will be getting public announcements during the process, and you can take necessary action in the process. Same case with 57A. They say in fast track CIRP also, the same possibility for you to get an alert when any sort of public announcement takes place. Next one, please. Now, section 21A, submission of default to IU prior to section 7 and 9 applications. Now, before it says, before filing an application to initiate corporate insolvency resolution process under section 7 and 9, the creditor shall file an information of default with the information utility, and the information utility shall process the information for the purpose of issuing the record of default. Now, see, we'll see the process also, because it lays an obligation for you to actually submit the information of default to us. See, as we go along with this, Suparna will also show you the format, the Form C, that in which the information is submitted, and also the process, how to log in and see that information. So it not only, there's obligation for you to submit that information, there's also a necessity for us to verify that, get that verified. Section 21, that details the process that is done. Basically, what happens in this process is that once the information of default is delivered to us, we have to remind the debtor at least 3 times. I mean, send that information to the debtor to authenticate that information. And in case he does not respond, we have to at least send it 3 times to him to confirm that information of default. And delivery, actually, once that is done, then we have to ensure that it's done by hand, post, or electronic means. See, the email address that you provide in the information that you submit is very important. If the email address is wrong, delivery of this information to the borrower obviously will not take place. This delays the process of getting the record of default generated. So I request you, when to look at all this information that you're providing, especially the communication details that you're providing to us. The email addresses need to be updated. This is one hygiene that the banks will have to, financial institutions will have to take, because at the time, see, when you're regularly submitting your information also of the various loans that you have, there are cases, you will also get cases where we are unable to submit this information for authentication to the borrower. Those cases, please attend to and have the email addresses, communication addresses corrected, so that information flows. And when the default occurs, we don't run into such issues. The general thing that we do is that the information that we use for sending this information to the borrower for authentication is that we use the addresses that he has provided to us when he has registered with us as in the information utility, the borrower. Or if that is not there, then we have, if that is not working, then we also have information that we take from the SIR side or the MCA side. And also we can use the information that you have submitted in the forms, schedules, Form C. So the information that you provide is very important in the entire process. Now, Regulation 23. And once we authenticate this information also, there is a color code to which we do it, actually, in the sense that, if the bank is in the second schedule of the RBI Act, once the information is authenticated, we show the information as in green code. If it is even after 3 times he has not responded, it is, in case of banks in the second schedule, it is treated as authenticated. Very important for you that you provide the correct information to us of the email addresses so that we can send it to him, the communication address. And even if he is not responding to that, we can still treat it, what you get an RoD is an authenticated information. Only in the case where he disputes, it is shown as red. In other case of other FCs, when it is even after 3 tries, it is not authenticated, it's shown as deemed to be authenticated. That's the only difference that is there. But otherwise, it's the same. The other access to information, who are authorized to see there, we are guided by the IBBI, regulated with IBI, and access to the information is basically for those people who are submitting the information, parties to whom the borrower is permitted for them to see, the board, the adjudicating authority, the corporate person and his auditors, So these is various people who can access this particular information. Now, see, we are regulated by IBBI, and just for comfort's sake, we'll have to say, see, the information that is there with us is kept secret, and great deal of care is taken in how the information is handled. We are also there is a regulatory oversight over our functioning. The systems and processes are also audited, and we have a risk management system, and the duties of the IU are also regulated. So the information that provided by you is treated with great care. Next slide, ma'am. We have already gone through this part. So the creditor shall file the information default with the information utility, and the information utility should process the information. As we have seen the process that takes place, we have to follow the process. There's a time frame in getting that done, and there's an email address that communication address that you have to provide to us that we follow. So kindly ensure that, in the entire process, what I would suggest is check out the communication addresses that you are providing to us. Ensure that you submit the information every month by the 7th of the next month. Default information, do not forget to submit, because it gives you further alerts. Even if the account is not in default with you, it provides a default earlier. The default information, if you provide to us, we are able to generate the RoD, and you need to provide this RoD for filing it in the case in the court. The time frame in resolving your issues in the court are much faster. Last slide. Next one, please. So when you provide your information in the Form C, that is a form in which you're providing a financial information, what happens is we send it to the counterparty, basically the borrower, for him to access the information. He can access the information. See, that is where the point comes in. Generally, when there's a default, they tend to either dispute or they don't respond. So submission information, one thing is that on a regular monthly basis actually helps solve this problem to a great extent. The other is he can dispute it, or he can give a no response. In case he authenticates it, obviously the information will be shown recorded as authenticated. If he disputes it, it's shown as disputed. And if it doesn't respond, shown as pending. For debt information with default, when there is a default, this is for regular submission of information. But when there is a default, like I've already said earlier, if it is a scheduled bank, even if he does not respond after trying this 3 times, we show it as, it is shown as authenticated. In other creditors, it is shown as deemed to be authenticated. So my request is kindly submit your information. So do a little bit of hygiene in your information that you have in your bank, so that information that you provide to us can be used for generating a recorded default. And we'll be able to generate if your information is correct, you will get a recorded default at the fastest. I think from now on, from the next slide onwards, the various format and other things, is how to log in and other things, Suparna will take over. Suparna, over to you. Thank you for all.
Thank you, sir.
Yeah.
Good afternoon, everyone, and it's a pleasure to see you all into such a large gathering. And here I'll be discussing about the contents that are available in the record of default, and also the process, like how to generate the RoD. So if we see, basically as per the IBBI IU regulations, the Form D, which is popularly known as the record of default, or we abbreviated it to RoD, contains 3 parts majorly: Part A, Part B, and Part C. So Part A contains the information of the default that has been submitted with IU, the information covering the debt, the submitter and the parties connected to the debt, the security interests, and the default details. We also find the status of authentication by the parties to whom the report is generated by the submitter, and the communication that has been that has been done with the party to initiate filings. In part B, we have the history of the filing of the information received by IU, and for the same, we also talk about whether it is a regular debt or it is a default, and what is the status by the party. In section part C, the communication made by IU with the other parties, the intimations that have been sent to the other parties, the co-obligants or the guarantors, is in respect to this submission has been captured. Section 65 of Indian Evidence Act clauses have also been added. Entire report comes with a digital signature from the NeSL authorized signatory. So for an easy understanding, it has also been with the it has also been made into a color coding. So if the color coding comes as green, that shows it is authenticated. If the color coding comes as red, that shows that it is a disputed one. And if the color coding comes in yellow, that means that it is a deemed to be authenticated one. So as per the recent amendment in Regulation 21, all the Schedule 2 banks under the RBI's Act 1934, all these Schedule 2 banks, in their case, the deemed to be authenticated case is no more applicable. So it comes that if the debtor does not respond after the initial information and the consecutive 3 reminders, then it is considered to be an authenticated one. So that means in case of Schedule 2 banks, it is only 2 cases: either it is authenticated or else it is a disputed. So I'll now run through the process, like how you can generate the RoD. So this is the home page. If you come to nesl.co.in, so from the home page, if you go to the login page, this is the page where it shows that it asks for the entity user. So on this page, what you can do is you can put the entity PAN number, and with the entity PAN number on the next field, that is the user ID, there you will be entering your user ID. This user ID can be of your choice, and this user ID is basically provided during the registration of the registered user in the IU system. Accordingly, after that, you will be putting the password and you will be putting this captcha. And once you put this captcha and click this login button, what happens is that an OTP is triggered to your registered mobile number. And with that OTP, you will be logging into the IU portal. So there, you have these tabs, that is the user management, the reports, help guide, post, and other. Okay, so from here we go to the report segment, and from this report segment we will be going to the record of default, and here we would be putting the request for the bulk record of default. Once we click this, we are navigated to this screen where it asks for the debtor PAN number. We will be required to put the debtor's PAN number, and we will be clicking this submit button. Once we click the submit button, you will be getting a drop down of all the creditors who have reported default against the said PAN number. So if, as per your requirements, supposedly you are representing some ABC bank, so if you wish your to generate the RoD from your bank, then you can click on yours. So reported any default, but you feel that you want to initiate a CIRP, and you know you are aware that because of the default broadcast, you are aware that some other bank has reported a default against that same PAN. So you can click that bank. With the help of the submit button, you can generate the RoD for the said PAN number. So once you click this submit button, a request number would be generated like this, which if you, oh, sorry, here you will find that a request ID has been created. And with this request ID, you can just click OK. And again, go back to this page. From this page, that is from here, you can go to download the bulk record. Once you click this, you will find that the same record that I had requested, like 94058, it shows that it was requested and it is in a pending status and the report has not been generated. So under such circumstances, you can just click the refresh button, and once you refresh it, you will be finding the next screen wherein you will be finding that yes, the report has been successfully generated for you and it is available in the zip file. You may find that there are other rows also. This actually shows the previous record of defaults that have been generated. This shows you the history of the previous record of default that has been generated from your end. So once you click this, this gets your system into a zip file, and then you can open up the RoD and check it out. So I'll be showing you the sample. Share it on the screen. Yes. Screen share. So here I think it's visible to everyone.
Yes, it is visible.
Yeah. So here you can see that it has been displayed that this is which means this is a RoD which has been generated and it is in the authenticated status. Okay, so here if you see, it's a dummy bank and it comes under the category of Schedule 2 bank. So that's why it has been marked as yes. And this is the name of the corporate debtor. So this is the unique identifier number, or you can say the loan number, the exclusive loan number that has been mentioned. And here the outstanding amount, the default amount, and the date of default, that all these details are been captured. And here we mention about the status of the authentication. So here we are mentioning it as authenticated. We may see that it has the color coding of green, as we had referred to earlier. So here you can also find that the filing of the default, that is the submission number. So supposingly you have been, this is number 1, but if you are doing a recurring submission consecutively for in every month, then what happens is the number of submission keeps increasing. So we would be getting the status of authentication of the latest submission that has been done. Latest means supposingly whichever is the latest submission that you have done. After that, after the process completion of the process, it will be showing over here. So represents that the date of submission that has been done and when the authentication process has been completed. The authentication process consists of triggering of one email, and it has been followed by 3 reminder emails with a gap of 3 clean days. That is, supposingly, if the first submission, if I take the case of this submission has been done on 21st of January 23, that is on that very day, first initial email has been triggered, and consecutively after completion, like 21, 22, 23, 24, on 25th day, we would be sending the first reminder. Again, after 25th, again 3 days, the second reminder, and again after 3 days, the third reminder. Once the third reminder has been sent, after that, another 3 days, and on the 6th, it comes up to be as the status categorized as authenticated. Okay. So as I was mentioning earlier, this is the first part, and this first part contains the unique ID number, the information received by NeSL date, the status, and the registration date, etc. If the debtor is also registered on the portal of NeSL, then here the date of registration appears, and even it also appears when the debtor has logged in into the IU system. This is information. That is the FC. Their information has been given here. So here we take the PAN number of the bank. We take the name, the relationship as a financial creditor or the operational creditor. Here, the address of the bank has been put, the contact number, the details, the email IDs. These are the email IDs where we send the dispute alerts, and at the same time, we also communicate from our side. Means if there is a request for some communication, or if there is a request for any information to be shared with that specific FC, then these are the email IDs that are being referred to. Similarly, in the second part, we have the debtor's details. Okay. So you have the company's name, the address, the PIN code, the registered address, the communication address, the constitution, the date of incorporation, the SIN number, their PAN number, the concerned persons who would be taking care of all these, and the email IDs. Email IDs are very important for us because these are the email IDs where we on the IU is doing their communication and is triggering the authentication emails. So it is a very humble request to you all that be very specific and accurate in filling these email IDs, because if these email IDs are not properly filled enough, the authentication process at times gets disrupted and it is not completed, and the emails start bouncing. So it is a very humble request that if this can be taken care of in a very sensitive way. Similarly, these are the details of the guarantors. We fill in up here. All the guarantors means how many number of guarantors, all the details of information of the debt appears, whether like it's the amount, sanctioned amount, the tenor, the expiry date of the debt, the installments, the kind of facility that has been offered, since how long it is due. All these things have been submitted here. Hence the security details, whatever the security has been offered in respect to that credit facility, all these details have been covered here. Now we start with the part where the communication with the debtor starts. So these are the email communication that has been done. So you see that whatever has been submitted in Form C, it is considered as the primary email ID, and there we are triggering the email. So we see, if you remember, on the first sheet, we saw that on 21st of January, the submission was made. So immediately the email was triggered on that very day with on the email ID that was being provided in Form C. Alternatively, we also take an attempt and find out if there is any separate email ID that has been provided in the NCA. If the email ID happens to be the same, then too the NCA emails are also being triggered. And if you see, it's like 25th, we have triggered the first reminder, then consecutively on 29th, we have triggered the second reminder. Then on 2nd of February, we have triggered the third reminder. So after the 2nd of February, if we count for 3 clean days, so it comes to 3rd, 4th, and 5th. So that's the reason we have categorized it as authenticated on 6th. If you remember, we have mentioned the authentication date as 6th of February. A report of the same, like submission date, default submission, amount, default amount, categorization, and date of submission. Date of authentication, sorry. Coming to part 3, you see that this part was consisting of the communication that has been done with the debtor, the principal debtor. Here on part C, we have captured the communication that has been done on part of the guarantors. Process has been followed for the guarantors also. So here it ends. The entire communication chain has been given, and this is the complete display of the RoD, means whatever is contained here. You have one for the deemed to be authenticated one. As mentioned, it is in yellow color, and you also find of one which has been, so this is in a disputed way. It's in the red color. Request if anybody has any questions or something, then otherwise we can go ahead.
Sorry, Suparna ma'am. Are we through with your part of the presentation?
Yeah.
Perfect. Thank you very much. Well, it was very informative and insightful, ma'am. I have a quick quiz that we are trying to run now. And so what is it? How long does it take for a record of default to be issued from the time we submit the information of default? This is a quiz that we'll be running. Please use the chat box over the next 2 minutes, and we will pick winners from this list, and they will be announced tomorrow. So please go ahead and leave your guesses on how long it takes for an RoD to be issued after we submit information of default. Use the chat box and leave your comments there, and we will announce winners tomorrow, and there will be a surprise gift as well for that. All right. Now, in the meanwhile, ma'am, we've got a few questions to start out with. And so we're going to start with these questions. I'm going to start with the first question for the day. Bear with me a second. So, and anybody else wishing to ask questions, you can leave your questions in the Q&A section, or raise your hand and we will unmute you to answer these questions. The first question is from Mr. Deepak Mundra. He says that as per Form C, mobile number or email ID, one of it is mandatory. We observed some clients, mostly from rural India, don't have email IDs. We provide mobile numbers to such cases. What is the process of authentication in such cases?
Well, if we do not have any, if it is a default, then email ID is a mandatory thing. And if we do not have an email ID, in case of default, it will not be submitted, firstly. And in case of email IDs are not mandatory, but yeah, SMS alerts would be received by the client, and it's advisable that an email ID should be taken, so that in future, taking into consideration, we can have the communication completed.
Perfect. Thank you very much, ma'am. And great. Just repeating my surprise quiz. How long does it take for an RoD to be issued before after the submission of record of default? So we're waiting for the answers. We've got quite a few. So we'll wrap this up after this next question, and winners will be picked from that list. Right. My next question I have is from Atul Kundale. His question is, for the non-individual customers, the reporting data at IU will help during insolvency. How will the individual data, the unsecured loan or secured loan for individuals, help IU? And what is the roadmap for the individual data usage which are reported at IU? I'd like, sir, perhaps you can help answer that question.
Okay, so
would you like?
In fact, yeah, one word. I hope I'm audible. Yeah. So in the initially itself, I said that one purpose of the record of default is to initiate corporate insolvency proceedings. But the other larger intent is to see how we can recover our debt even without initiating insolvency proceedings, which can be long drawn and time consuming and also entails a lot of cost. And this is true for all segments. How you can recover your debts even without initiating corporate insolvency proceeding, and of course in individuals, any case insolvency, the necessary law has not been notified. So what happens in the default is reported in case of individual, like in the case of in case of corporate debtor, default notification goes to all the creditors of the debtor. So all creditors of the debtor are cautioned that yes, there's a default. So this happens across any kind of customer segment. So this becomes a very, very useful credit monitoring tool for any creditor. So that is a very useful purpose which can be served, especially in the individual segment where the relevant law has not been notified, but it can also be useful in the corporate segment where the law is notified, but one should not like to take every case to insolvency. Because if you can, get your work done, even without taking the long handle of the law, so then would it not be good?
Absolutely.
So that is the intent. The recourse to law is of course there by way of insolvency proceeding if it's a corporate debt. But even without taking recourse to law, you can also recover your debts by using the default broadcast facility of the information unit.
Thank you for that, sir. Our next question is from Rini Loyola. I'm just going to unmute Rini. Please go ahead, Rini, and you can ask your question.
Hello. Yeah, good afternoon, one and all. I'm Rini Loyola from South Indian Bank. I just want to I have an idea about date of default, which was not discussed in the class. The date of default. Now, for example, if the account has not turned NP or there's no default, still it goes to IBC, right? So in that, the relevance of date of default, can you just appraise us regarding that?
Okay. So it's a generally accepted principle that earlier a stress is addressed, the better it is. So that is why I think date of default in the context of IBC could mean even delay in payment even by a day. So if there is now, of course, one counter argument you can say is that, at the very first instance, I don't want to initiate insolvency proceedings. So I come back to the original argument that submission of information to the information utility does not necessarily mean that you are going to initiate insolvency proceedings. There's ample opportunities which are given to the corporate debtor to regularize the account, to even the default broadcast may not be required. For example, when you first submit the information to the information utility, so the debtor gets immediately the information utility gives the information to the debtor. So at this point of time, if the corporate debtor regularizes the account, so the information stays between the creditor and the debtor concerned, and it doesn't go out, and the debtor gets an opportunity to regularize the account, and it remains within the two of them. It remains private information. After that, we give 3 more reminders. At any point of time, if he regularizes the account, the financial creditor can submit a fresh information, and in that case, the account will get regularized. Then there's the question of record of account. Now, assuming a situation is there where the corporate debtor is in stress and is actually not able to pay, then the corporate debtor, then the record of default will be issued. As many of you have said, it could take around 15 days time if all the details are correct, email addresses are correct. So after that also, it's not necessary that you initiate insolvency proceedings. But what will happen is all creditors come to know of it. They can take a collective decision as to what could be the best course of action. It could be a reorganization. It could be a resolution outside IBC. So at the end of it, what I'm trying to say is that please report information at the first instance of default. You do not have to worry that the default is not very serious. It can be regularized. If it's regularized, it's fine. So after that, a fresh information will get submitted, and nothing happens. But if you submit information at the first instance, it could lead to early identification of stress. It could also make the corporate debtor come to the negotiating table. He will realize that there's something which needs to be done. It could be by way of additional collateral. It could be way of sale of non-core assets. So at that point of time, there's still value left in the corporate debtor. The more stress lingers, value gets eroded, and later on the debt becomes unsustainable. And then at that point of time, maybe the financial creditors may not be able to restore the full value of the debts. So please report default at the first instance. 1. Secondly, please report with full particulars. As you know, we communicate with the debtor only through the email ID. Please report the correct email ID. Without that, we'll not be able to communicate. Without that, we'll not be able to get the information of default authenticated, and without that, the issue of RoD will also get delayed. So if you report the correct information with the correct details, the email ID and other particulars, then the record of default can be timely issued, and timely any action can be initiated for resolution of the stress.
Thank you for that, sir. I have another question. My next question is from Kajal Pillai. Kajal asks that please confirm whether NPA customers having DPD more than 90 days to be reported in default section, or any customer having DPD starting from first day to be reported in default section.
Anybody would like to respond to that, Suparna or Sanjanath?
What exactly do you mean by DPD, madam? What is the abbreviation standing for?
I would assume.
Anyway, no issues, no issues. So I would like to just clarify
Kajal,
that. Yeah.
Okay.
Days past
Kajal
due.
yeah,
Okay.
I'm trying to see if I can
Yeah.
unmute her.
No, days past due. She said that days past due.
Yes, yes, correct.
Any default, at the first instance, you can report it. Even if you are reporting subsequently, that will get sent to the borrower for authentication. So your question regarding, if it is beyond 90 days, it's an NPA. It doesn't anyway stop you from reporting that. So we'll get the authentication and the RoD will be generated, and that can be used for filing.
Right.
I hope
Yeah, but just to supplement it, please do not wait for the account to be an NPA, because by the time it's NPA, then already a lot of value of the corporate data has got eroded. Again, I would like to stress is that early identification of stress helps in preservation of value. So please report information to the IU, and you do not have to worry whether the debtor's reputation, would be eroded, he would feel offended, because as I said initially, the information remains only between the IU and the debtor concerned. It's only after he does not respond, after 3 reminders, it's only then the default broadcast goes to all creditors. At the initial stages, it's only a one-on-one email between the debtor and the IU. So you don't have to worry about the corporate debtor's reputation getting tarnished, not at the initial stages. If you regularize that, it stays between him, his reputation stays intact.
Thank you, sir, for that. Just before we go to the next question, I'd like to remind everybody that NeSL today has a dedicated line for record of default. It's a hotline. You will see this up on your screen. You can always reach out to us for any information, any knowledge about record of default, and anything that you need as support and advice towards managing your record of default.
I'd just like to supplement that. I'd just like
Yes,
to
sir.
supplement that a bit. This is a mobile number. It is not a helpless number. It is addressed. It would be answered by an officer in the operations team. So it is not a helpless number. You will not be put on hold. It will be straight away answered by an officer in our operations team, who can immediately respond to your queries and come up with solutions to any issues you're facing in submission of information of default or some downloading of RoD.
Thank you very much for that, sir. Our next question, and perhaps we'll close this session with this. Last question from Raki Kulkarni. Can we update backdated default in the system?
What I understand is that you have not reported the default earlier, that you would like to report the default now. It can be done, but at the same time, like we said, the purpose of reporting a default is to get the RoD and start your action. So if you wait, like the economic benefit, the possibility that the company might have secreted the assets elsewhere, or you lose value of the asset, those things remain, that you have not taken action in time. But you have cases where you have not reported default area. Please do report the default at any point of time. You can do that.
Thank you very much for this, sir. Once again, please, leverage our dedicated mobile number for record of default. Please be in touch with us. Feel free to reach out to us for any more questions. We'll end this session now. I'd like to first start with thanking Sri Debdoti Rai Chaudhary, our MD and CEO, for joining this and facilitating this session for us. And thank you very much to Mr. Surendranath and Suparna Chaudhary for their valuable insights. And finally, a big thank you to all of our audience who joined us despite their busy schedule. And we look forward to having more sessions like this with insightful information about RoD and other abilities of the IU. We'll hope to look forward for you to join this session. Thank you very much once again. Thank you once again, sir.